Welcome to All Things Social Security. My name is Stephanie Joy of Joy Disability. I am a Social Security disability attorney, and I would like to invite you to watch our daily video tips on the Social Security disability and SSI claims process each day at the new time of noon Eastern Standard Time here on YouTube on this channel. And on Wednesdays at 1 p.m. Eastern Standard Time, we have our live Q&A live stream. So you are welcome to join that as well. Ask your questions, get there on time, and you'll be one of the first answered. Thanks so much and have a great day. Enjoy the video. Michelle Mazarek. Hi, Michelle. Good to see you. Thanks for being here. I missed out on over 6 months of back pay because my otoneurologist, kept referring to my vestibular migraine as a headache. I know, they're so sloppy with their verbiage, right? And they're medical professionals. I didn't even have a headache, nor did I ever say that I had a headache. But that's what he apparently diagnosed you as. Although I would assume, Michelle, you had this, vestibular migraine eventually diagnosed. I wonder if this was the problem. And guys, you should really check your records if you're pro se or not, because I had a case where the onset was later than the person was really overly impaired for, but it was still kind of a gift because the person would be done with, and it was a younger person. So the judge really was, I thought really good about this because, what was it? I think it was Sjogren's. It was suspected for 3 years, suspected. And so the impairments that would be attributable to Sjogren were not yet due to a diagnosed impairment. And so this was used to not go all the way back to what we wanted, but we got really what the big kit and caboodle was when we expected a loss altogether because it was a remote DLI case with a young person. You can't get worse than that. But so the date of onset that the judge determined, which worked for getting her SSD instead of having her be stuck with SSI for the rest of her life, was because they kept kicking the can down. So sometimes I think we have to get very pushy with our doctors and be like, I need a diagnosis. So there's no reason for something to take 3 years. I don't think. There were specialists involved and they're all saying suspected. They all just don't look at the fact that it's been suspected for 3 years. So go in, do your analysis, and give a diagnosis. That's it. I think sometimes we have to be a little bit more, I shouldn't say aggressive, because that's going to probably get us kicked out of the doctor's practice, but very proactive, maybe complaining, maybe pushing, maybe begging, whatever it is. It's like, I need a diagnosis. It's one thing, we can't expect a diagnosis on those kind of ruling out other things until you can narrow it down and this is the only thing left thing. That does take time. But I would think if it's more than a year, I would start to get a little antsy. And I'm saying a year generally. I can't speak to all impairments. I'm just, speaking to the one I have, not the one I have, but the one that I was just talking about. But that can affect. And you're spot on, Michelle, because if there's no diagnosed condition, that Sjogren's is not an MDI, medically determinable impairment, until it was diagnosed by the doctors in the acceptable way that the medical profession does it, the medically acceptable method. So it can be tricky. It's all things that there's always many pennies in the air you're juggling, trying to make sure, does that cover, was there a diagnosis of that properly? I mean, there's so much that goes into it to make sure all these things are done. Hey there, that was one of our little Q&A clips. I hope you found it informative or helpful or just enjoyable. I am attaching a related video that we have put together a while back that is on a similar topic and or an extension of what we were just talking about. So if you needed some more information on that, that's a place to start. You can also look in our playlists. There is a ton of them. I think there's over 1,000 videos. So there's almost every topic in the world touched upon in some way, shape, or form. And again, as a reminder, you can always put in the comments any kind of question you have, even if it's unrelated to this or any other video. I will talk to you later. Carry on. Hey guys, Stephanie Joy here from Joy Disability. Just wanted to touch on the misconception that a medical condition or a diagnosis that is a significant one is going to win a case because you have a serious diagnosis. Not true. You need the diagnosis to get to the next step in the sequential evaluation process, but the diagnosis itself isn't going to win the case. With the pseudo exception of compassionate allowances, of which there are not that many relative to the amount of diagnoses out there. And even with a compassionate allowance, you still have to have the current evidence of current treatment and certain criteria met for that to stand. Okay, so what does this mean? Diagnosis isn't going to matter. It matters. It's one of the first steps in the evaluation process that the SSA must go forward with. You have to have valid diagnosis, one or more. More diagnoses obviously might produce more impairments and limitations functionally. And the diagnosis has to be diagnosed in an acceptable manner. And it typically is, so that's not something that I would really worry about. If you were diagnosed with something many years ago before you became disabled, and by the way, that's why diagnoses don't win a case, because most people have diagnoses and they work for years thereafter. It's when the diagnosis of the medically determinable impairment, MDI, once it's determined to be a severe one, which that's not a huge burden either, I might add. That's never our big fight. Once that happens and it starts limiting the person enough that it eliminates their current job is when they tend to either be terminated because they couldn't function well enough to satisfactorily perform the job duties. And by the way, there's a video on getting a statement from your employer about that, which can be really helpful. But also they get out of the first job, then they have to actually, if they have a case, then they have to prove that their impairments prevent all jobs. So that's a whole nother term of art and a whole bunch of legal input, factual and legal input that goes into proving that if it's so. Okay. So the diagnosis itself, again, is not going to be the deciding factor. It's just going to get you across into the next yes in the tree of yes, no's. If yes, you're disabled, or if yes, you're not disabled. It gets you down to where they'll still consider your case versus knocking it out because there's nothing more than a diagnosis. So the diagnosis being currently treated for now, not 2 years ago only, now. I mean, it's nice if it was treated with some duration, for sure. That's more longevity, and durational records are best, but you can't win unless it's now, generally speaking. So you need to be treating for that impairment. And of course, as you'll see in my other videos, treat for every other little one too, not just the one that took you out of your job, because that took you out of one job out of 12,000 that you have to prove you can't do. But those other little impairments that you don't really think about much because you can do workarounds and not have to use that limb or that finger or that this or that. They're the ones that can actually make your case be a winnable one. Because remember, you can't prove, it's not like workers' comp where you prove that you're 70% impaired. It's a totally different definition. And we have to prove that there are zero, for all intents and purposes, zero occupations we can do full time. So even if we could do some activities part-time, that doesn't count against you unilaterally, but that we can't do the job that exists in substantial numbers in the economy full time. So if we can do one job out there that there's only 2 of them in the entire country, that's probably not going to be considered substantial numbers. So it's a whole, more of an official number, a numbering. They have the vocational experts provide the numbers. They use the Dictionary of Occupational Titles and other resources to find out the supposed numbers in the economy. The information is often very outdated. There was a big news article about that finally, what we've been complaining about for a long time. But anyway, so the medical records from your current treatment are not only going to say that there's a diagnosis, but they're also going to, if your doctor is, in my opinion, properly doing his job, or your NP or whoever, describing how they affect you day to day. Because, let's face it, a diagnosis of something that is not terminal and doesn't affect us much, who really cares? I'm diagnosed with a freckle up here, but it doesn't bother me. Is it an impairment of sorts? Sure. But it doesn't bother me. It doesn't limit my work effort. So, I mean, it might if I was going to be like a porcelain model or something, but I'm not. So it doesn't knock out all these substantial jobs. So you have to have current treatment with all of those diagnoses for your strongest case. Any that you forego and decide it's too inconvenient to treat for, just know that you are diminishing the strength of your case. Doesn't mean you might not still win by any means, but you have diminished the strength of it by and large. So diagnosis won't get you there. It's how the functional limitations are caused, to what extent, how severely, and is it enough to prevent all occupations? Simple, sedentary, 5th grade skills, unstressful, supposedly. I think all jobs are stressful, but anyway, that's not how they look at it. Routine, 1-step, 2-step, for those that can't remember very well. We got to eliminate all those jobs one way or another. Diagnosis, treatment, diagnostic test, treatment. Can I emphasize it anymore? Anyway, diagnosis isn't going to win it. You have to treat, and you have to treat with certain providers. Not certain providers, certain professionals for a stronger case. Some professionals are acceptable medical evidence, some are not. So you need to know the difference. So do your homework or find someone who can do it for you. Okay? Alrighty. Hope that helps. Bye. Hello again. I hope you enjoyed the video. I hope it was helpful, if not just a little bit informative. In the event you have a Social Security question you want addressed, please feel free to make a comment below and ask the question, even if nothing to do with this particular video. And just a quick, again, reminder, we have our daily video shares and tips around noon every day of the week. And on Wednesdays at 1 p.m. Eastern Standard Time, we have our live Q&A session where you can come in live and enter your questions in the chat. And we all pretty much have a good time for an hour or two. I look forward to seeing you there, hopefully. And lastly, don't forget about our benefactor memberships. They're very reasonably priced. The first one is very nominal and you get a few perks, but on a bigger scale, it contributes to us being able to fulfill a mission of assisting certain people with representation that would otherwise not be able to get it. We look forward to continuing to do that. And so far it's working out like the bomb. So thank you for being here. I appreciate it. Bye-bye now.